Employee relations. Labor relations. Employee engagement. Terms and concepts. Part 2. PHR, SPHR, SHRM-CP, SHRM-SCP exams. By Human Resource Prep. Labor Management Relations Act of 1947, LMRA. This law is also called the Taft-Hartley Act. The LMRA sought to bring about a balance of power between unions and management, and restricted the activities and power of labor unions. It designated certain union activities as unfair labor practices, ULP. The Taft-Hartley Act amended the National Labor Relations Act, NLRA, by prohibiting unions from engaging in certain unfair labor practices. The LMRA prohibited the following activities: jurisdictional strikes, wildcat strikes, solidarity or political strikes, secondary boycotts, secondary mass picketing, closed shops, and monetary donations by unions to federal political campaigns. The Taft-Hartley Act also allowed states to pass right-to-work laws, which banned union shops. Labor Management Reporting and Disclosure Act, LMRDA. This law is also called the Landrum-Griffin Act. The LMRDA protects the rights of union members from corrupt or discriminatory practices of labor unions. The LMRDA was enacted to ensure basic standards of democracy and financial integrity in labor unions operating in private industry. The LMRDA promotes labor union and labor management transparency through reporting and disclosure requirements for labor unions and their officials, employers, labor relations consultants, and surety companies. The major provisions of the LMRDA are: 1. A Bill of Rights for union members. 2. Requirements for reporting and disclosure of financial information and administrative practices by labor unions. 3. Requirements for reporting and disclosure by employers, labor relations consultants, union officers and employees, and surety companies, when they engage in certain activities. 4. Rules for establishing and maintaining trusteeships. 5. Standards for conducting fair elections of union officers. 6. Safeguards for protecting union funds and assets. The Office of Labor Management Standards, OLMS, in the U.S. Department of Labor, is the federal agency responsible for administering and enforcing most provisions of the Labor Management Reporting and Disclosure Act of 1959.
Landrum-Griffin Act, in pictures. The Act regulates the internal workings of unions, and protects union members from abuse by corrupt leaders.
Local nationals. These persons are also called host country nationals. These are employees hired for jobs in their own country. For example, a Norway citizen who is employed at Microsoft's subsidiary in Norway is a local national. Expatriates. These persons are also referred to as home country nationals or parent country nationals. Expatriates are employees who work outside their home countries for a period of time, with the intent of eventually returning to their native countries. Third country nationals. These are employees who are neither from the home country nor the host country. An example is a French citizen who is assigned to work in the Google's subsidiary in the United Kingdom. Impatriates. These are foreign national employees who have been transferred to work in the home country of an international organization.
Home country national, host country national, third country national, in pictures.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Lockout. The exclusion of employees by their employer from their place of work until certain terms are agreed to. Maintenance of membership clause. Contract clause that states that an employee may or may not choose to join a union, but once the employee joins, he or she must maintain membership for the duration of the contract. Mandatory subjects of bargaining. Mandatory bargaining subjects are those that directly relate to the NLRA requirements. A refusal to bargain regarding a mandatory bargaining subject is a violation of the NLRA. Negotiations on these subjects may continue to the point of impasse. Mandatory bargaining subjects include wages, hours, merit increases, bonuses, pensions, profit sharing, health and welfare plans, discharges, grievance procedures, disciplinary procedures, drug testing, seniority, promotions, transfers, health and safety, work assignments, and plant closings. Voluntary, or permissive subjects of bargaining. These are bargaining subjects, for which an employer or labor organization may choose to bargain, but are not required to do so. A refusal to address a voluntary, or permissive bargaining subject, is not a violation of the NLRA. Examples include the following: internal union business, inclusion of supervisors in contract, designation of negotiators, marketing strategies, price of employer's product, use of union labels, and taping, or making transcripts, of negotiations. Illegal subjects of bargaining. These subjects are unlawful, under the NLRA. These include the following: closed shop clauses, union shop clauses and right-to-work states, hot cargo clauses, and provisions that violate the NLRA, or federal, or state employment laws.
Permissive bargaining subjects, in pictures.
Mediation. This is an alternative method of non-binding dispute resolution, involving a trained impartial third party, who assists disputing parties reach a mutually agreeable decision, or settlement. Steps in the mediation process. 1. Introductory remarks. 2. Statement of the problem by the parties. 3. Information gathering time. 4. Identification of the problems. 5. Bargaining and generating options. And 6. Reaching an agreement. National Labor Relations Act, NLRA. The NLRA is also known as the Wagner Act. The NLRA guarantees the right of private sector employees to organize into trade unions, engage in collective bargaining, engage in concerted or collective action, such as strikes, and it banned company-dominated unions. The NLRA established the National Labor Relations Board, NLRB, to prosecute violations of labor law, and to oversee the process by which employees decide whether to be represented by a labor union. It established collective bargaining rules, and identified employer unfair labor practices.
Mediation versus arbitration, in pictures.
National Labor Relations Board, NLRB. The National Labor Relations Board is an independent federal agency, vested with the power to safeguard employees' rights, to organize, and to determine whether to have unions as their bargaining representative. The agency also acts to prevent and remedy unfair labor practices committed by private sector employers and unions. The NLRB has the authority to conduct union representation elections and investigate unfair labor practices. Negligent hiring. This is a legal claim made against an employer for hiring an employee who the employer knew or should have known, based on a reasonable pre-hire investigation of the employee's background, posed a risk to others in the workplace. Negligent retention. This is an employment-related claim, in which a complainant asserts that an employer failed to discharge an employee, who management knew, or should have known, had a propensity toward violence, sexual harassment, dishonesty, or misconduct, based on evidence from prior occasions, during the course of employment. Neutrality agreement. This is an agreement between a union and an employer, under which the employer agrees not to oppose a union's attempt to organize its workforce. Newsletters. Newsletters provide regular updates to employees on company information, including business updates, share employee news, report industry trends, company projects, and announce upcoming events. Newsletters, however, are a form of one-sided communication. Nip-in-the-bud cases. NLRB cases involving employer ULPs during a union's organizing drive that frees an organizing effort. Traditional nip-in-the-bud employer unfair labor practices include threats, coercive interrogations, surveillance of protected activities, improper grant of benefits, and unlawful employee discipline, including discriminatory discharges. No lockout clause. This is a labor contract stipulation in which the company agrees not to lock out workers during a labor dispute for the life of the contract. Norris LaGuardia Act. This act guarantees workers' right to organize and restricted issuance of court injunctions against nonviolent union activity such as strikes, picketing, and boycotts. It also prohibited yellow dog contracts, which are agreements between a worker and an employer, in which the worker agrees not to remain in, or join a union, as a condition of employment.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
No strike clause. A contract stipulation, in which a union agrees not to strike, during the duration of the contract. Ombudsman. A designated impartial individual, not involved in the dispute, from whom employees may seek counsel, for resolution of their complaints. An ombudsman is an independent official, with responsibility for investigating complaints of injustice, caused by maladministration, and makes recommendations to resolve them. An ombudsman can mediate, and refer the matter for further alternative dispute resolution, ADR, but may not resolve disputes. Open shop. A workplace in which union membership, and payment of dues, is not required for an employee to continue employment. Right-to-work laws, enacted by states, make workplaces open shop. Organizational culture. The underlying beliefs, assumptions, shared values, and ways of interacting that contribute to the unique social and psychological environment of an organization. Organizational climate. This refers to the way people experience the work environment. What is it like to work here? How do employees feel when operating in the firm's culture? How do business conditions, management decisions, and the actions of leadership affect the general mood? Organizational picketing. This is a type of picketing done to persuade employees to accept the union as their representative. Open door policy. An open door policy indicates to employees that a supervisor or manager is open to an employee's questions, complaints, and suggestions. The objective is to encourage open communication, feedback, and discussion about any issues employees may have. Union organizing process. Confirm employee interest, sign authorization cards, demand recognition from employer, petitioning the NLRB, NLRB Conduct Elections. Pattern bargaining. A collective bargaining strategy, where a union gains a new and superior entitlement from one employer, and then uses that agreement as a precedent to demand the same entitlement, or a superior one, from other employers. Also called pattern bargaining, whipsawing, or leapfrogging. Peer review panel. A type of alternative dispute resolution, ADR, in which management and non-management employees, trained in company policies, procedures, and work rules, hear disputes, and make decisions which, depending upon the particular program, can be final and binding on both parties to the dispute. Phased retirement. A human resources tool that allows full-time employees to work part-time schedules while beginning to draw retirement benefits. This allows managers to better provide unique mentoring opportunities for employees, while increasing access to the decades of institutional knowledge and experience that retirees can provide. Policy. A broad statement that reflects an organization's philosophy, objectives, or standards concerning a particular set of management or employee activities. It is a statement of intent and principles to guide decisions. Policies are implemented as a procedure or protocol. Procedure. A detailed, step-by-step description of the method of handling an activity. It is a series of steps taken to accomplish an end.
Understanding policy, process, and procedure through pictures.
Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button.
Positional bargaining. A negotiation strategy that involves holding on to a fixed idea or position of what one party wants and arguing for it alone, regardless of any underlying interests. It is a winner-takes-all, adversarial, zero-sum type of negotiation that is competitive rather than cooperative. It is also called hard bargaining or distributive bargaining. Principled bargaining. This negotiation strategy is about finding a deal that will benefit all parties involved. Principled negotiation is based in a win-slash-win philosophy, seeking mutual benefit and shared solutions through the negotiation process. There are two forms of principled bargaining: integrative bargaining, a mutually beneficial give and take, and interest-based bargaining, a focus on harmonious interests.
Positional bargaining versus integrative bargaining, in pictures.
4 premises of principled negotiation. The principled negotiation is based on 4 premises. 1. Separate the people from the problem. 2. Focus on interests, not positions. 3. Invent options for mutual gain. And 4. Insist on objective criteria. Progressive discipline. A system of discipline, where the penalties increase upon repeat occurrences. It is a system of increasingly severe penalties for employee discipline. Step 1. Verbal warning. Step 2. Written warning. Step 3. Suspension, and/or final written warning. Step 4. Termination of employment. Step 5. Appeals process. Project team. A team which comes together for a specified period of time. The team members have different functions and are assigned activities for the project. Promissory estoppel. The doctrine that a party may recover on the basis of a promise made, when the party's reliance on that promise was reasonable, and the party attempting to recover, detrimentally relied on the promise. Public policy exception. An exception to the employment at will doctrine, which states that employees cannot be fired, when the termination is against an explicit, well-established public policy of the state. The public policy exception can be applied in 4 areas: employees who refuse to break the law, employees who are whistleblowers, employees who participate in activities supported by public policy, employees who act in accordance with legal obligations. Railway Labor Act. This act provided railroad employees the right to organize and bargain collectively. The act covers both railroad and airline employees. Recognitional picketing. This is picketing done to obtain an employer's recognition of a union as the bargaining representative. Reference guide. A reference guide provides employees with quick and easily accessible information. It is designed for users who know the material, but need a guide to remind them of the steps. A reference guide can be an employee phone list, company product list, or user manuals. Respondent superior. A Latin term which means, let the master answer. It refers to the employer, who is liable for the negligent actions of its employees, within the course of employment. Safe harbor. This is a provision in a law or regulation that provides some measure of protection from liability, if certain conditions are met. Salting. A labor union tactic, involving the act of getting a job at a specific workplace, with the intent of organizing a union. A person so employed is called a salt. Secondary boycott. This is a boycott of an employer, with which a union does not have a dispute, that is intended to induce the employer to cease doing business with another employer, with which the union does have a dispute.
We offer a standardized online course for the PHR and SPHR. PHR-SPHR self-study course on Teachable.com. The course includes basic, intermediate, and advanced resources designed to enable you to earn the PHR and SPHR exams, with over 1,000 standard questions. Check out the link in the description box below. And with that we come to the end of today's lesson. Check out the description box below for additional resources towards earning the PHR, SPHR, SHRM-CP, and SHRM-SCP. Facebook Practice Group. Class Marker PHR, SPHR, Practice Exams. Books on Amazon. Teachable PHR, SPHR online course. Remember to subscribe and like this video.